paragraph 9B language that would read as follows: all stored water shall be covered by a storage agreement, and except as provided in subsection 9F below, which lists the existing storage agreements that we think were carved out of this requirement anyway. And it's not just AVEX; it's also Antelope Valley Water Storage, Sheep Creek Water, Rosamond, and Palmdale Water District. So to repeat, we're willing to give the Watermaster engineer all the assistance and information we possibly can to understand how these projects work and how they impact the basin. It still seems to us that we don't want to have to enter into a storage agreement per se. Call it something else, call it a monitoring program, but it should not be incorporated in the general requirement for storage agreements going forward from the day the judgment was entered. I can't emphasize, we're uncomfortable bringing this to you late to the board. I've had talks with Robert Cush, with Stan Powell. We understand what they're saying, but the board at AVEC is adamant that little saving language carving out present banking operations should be put in subsection 9B, and with that, AVEC completely supports the adoption of the Watermaster rules. And I think, Dwayne may have more to say about this later, but that's our only concern. And again, let me emphasize, we're not trying to hide the ball or anything from the Watermaster or the engineer. We just think the format of a storage agreement wasn't meant to cover the existing operations. And I'm happy to answer any questions the board may have on AVEC's position.
Hi, this is Warren Welland with County Council. Are you able to hear me?
Yes.
Yes, Warren. Yeah. My office represents Los Angeles County Waterworks District number 40. I was actually trying to speak earlier, but I think I was on mute. I wanted to address Mr. Powell's comments and Mr. Cush's comments regarding the language pertaining to the District 40 AVEC lease agreement. First, I want to point out that the application for approval of the transfer is on the agenda today for approval. So perhaps that item could have been heard before this one. That's number one. And then secondly, we believe that it's appropriate for this particular arrangement to be in the rules and regulations because it's unique. It involves two large public agencies who are involved in providing water service to a large portion of the valley. And this basically sets forth in the rules and regulations the formula that will be used to determine the amount of the transfer. And the formula will produce generally a different number every year because it depends on the amount of water that District 40 gets from AVEC each year. We think that just as a matter of convenience and clarity for future generations, this would be a good thing. It would make it easy for people to understand the exact amount of water. It will assist, in planning purposes and what have you. So we think that the language is properly in the agreement. Again, the transfer is on the agenda today. Thank you.
Thank you, Warren. Any other comments? Public comment.
Yes, this is Stan Powell. I have an additional comment. Can you hear me?
Yes. Go ahead, Stan.
Yes. So my additional comment is there is a transfer on the agenda today between AVEC and Waterworks 40, but it does not appear to me to be the same program that has been placed into the rules and regulations. And as an example, I believe the application itself is for a set quantity of water that only represents the amount that might have been transferred from 2016 to 2020, and it doesn't cover future amounts. The second issue with that is I will probably have some comments on that transfer when we get to it onto the agenda. So those were my comments. Thank you.
Thank you, Stan.
Yeah, this is John Ukestead, and I agree with Robert Bush and Sam Powell. Okay?
Thank you. Any other comments?
Yeah, can you hear me? Bob Hightower, Provincial Water
Yes.
Company. I just had a question about the 9F, the pre-existing banking. I know you've been discussing that, and it talks about AVEC and other entities there that have banking projects. The information provided, say, by AVEC to the Watermaster, is that going to drill down into the small agencies like our mutual water company that have purchased DWR water has to be stored with AVEC? Is that listing going to be individually by AVEC to Watermaster, or is that still too low of level to be considered in this? I'm just wondering how that works. We don't, our banked water, we lost the shuffle between AVEC and the Watermaster.
This is Jim Markman. Let me try to respond. We'll give the Watermaster engineer whatever she wants to look at that has something to do with the operation and management of the basin. I don't know if she'll want to know who's storing how much at any given time. That would be up to her. Those are all public records, but I don't think there's any intention of the Watermaster or its engineer or AVEC not to honor whoever's banking there and the obligations we have to them. That I don't see how that could be disturbed by a process of providing monitoring data to the Watermaster engineer.
Okay, and then the other language in there talks about documentation with the Watermaster if we're using that banked water. The question is, would we individually, say, our mutual water company, do that directly with the Watermaster, or we would do that with AVEC, and AVEC then would do that with the Watermaster? Is that a step process with AVEC, or I'm not sure what the language really means in there in terms of interface with the Watermaster in terms of banking?
I think the Watermaster, we've talked to the engineer and Craig about this. I think the Watermaster wants data that will help manage the basin, and it's just physical data. What's happening physically when we put it in, and where we take it out, and where it's used. And we'll be supplying that information to the Watermaster, but I don't think the Watermaster would be inclined to look twice for the same information. So we would just have to leave that to the, and I think we will have an arrangement that's formalized in some way with the Watermaster engineer considering this monitoring. So these are good questions, and they'll be considered, but we're not going to try to create more paperwork or headaches for people who are banking in our facility. So AVEC's going to provide whatever it can to be helpful to the Watermaster.
Okay, yeah, and we don't want any more paper than necessary either.
Right.
We just, our relationship with AVEC and the banked water, if we continue with that relationship under the pre-existing banking conditions, that's fine. I just wanted to bring it up to make sure that we're still on track to do that, and AVEC interfaces with the Watermaster with any of that banking water that perhaps we would use.
No, and nothing changes AVEC's relationship to you.
Okay, just want to put my oar in the water there, with all this different language in there to make sure. Thank you.
So Phyllis, you don't have any problems with the existing banking programs? Any mitigation, anything that you think might need there?
Don't have the information that we need to be able to assure you that's the case. We thought that we've gone through 2 storage agreements, as you know, so far, and we thought we would be going through storage agreements for the pre-existing banking operations. And I guess this is going to be a legal decision, not mine. So I will leave it to the attorneys. I will just say that we've been working with 2 other banks on details for their storage agreements, and they're moving forward. So AVEC would be the only one without them. I guess maybe the other ones won't need them now either. I don't know. I'm trying to understand why there's less paperwork if we're still going to have a monitoring agreement or an MOU. It seems like that's just also an agreement with the Watermaster. So I'm just the Watermaster engineer, and I'm not making this decision. It's a surprise to me that this isn't happening. We would like to understand what's going on. We have continual comments from the advisory committee about how do you know that this is happening? How do you know this is occurring? And we're just trying to make sure that everything is transparent and understood and able to move forward. So that's.
Well, I like what Stella said. I like what our attorney said. We can't make these rules or regs perfect. They're going to be a living document. As Mr. Markman already said, there has been a lot of time spent on this, and we keep punting it every month. We need to move on. We need to approve what we have, and stop the bleeding, so to speak, financially. And then we can always discuss any changes that we want to make down the road. Nothing is going to be perfect. So I highly recommend that we do not postpone things any further. We follow our engineers and our attorney recommendation, approve the rules and regs as they are, and then entertain any changes that we want to do going forward.
Go ahead.
Maybe this is Jim Markman again. I want to point out some things that are of concern. As I said, we're happy to get all the information the Watermaster can digest from our existing storage agreements, and we know the ones that come online after the judgment was entered are going to be subject to the origination of a storage agreement before we begin operations. But there's several things. If you look at 9G of the Watermaster rules, there's several things that are supposed to go into the storage agreement and its process that really have nothing to do, or it's too late, however you want to look at it, it wouldn't apply to an existing operation. Identification of the lands to be used for recharge, if applicable, which the Watermaster would have discretion on input. The lands are the lands to be already being used. Description of delivery and recharge methods, infiltration rates, all of that, which comes out in front of operation, is not relevant to existing operations. Conceptual designs, location, depths, and construction details of the basins. All this is meant for the Watermaster to review the operation before it starts. Environmental documentation, that's already there. We're happy to share it, but it's not a go-forward look at it. Description of extraction methods and facilities. Provide the recovery. Here's a good one, 7. Provide the Watermaster prior to recovery with the anticipated recovery quantity, rate of recovery, and location and constructions of wells. That boat is left years and years ago, and millions of dollars have been spent on that item. So there's no reason for an agreement that applies to that process. Some of the rest of it is.
Mr. Markman.
Yes.
Mr. Markman. So, yeah. In my mind, this is Adam. In my mind,
yes,
it's exactly what you said. You know, we can't apply rules or regulations retroactively. Can we work on those under a separate agreement or some separate understanding for all things that have happened pre-judgment and pre-Watermaster?
Yes, that's what we would like to do. We're ready to do that. Yes.
Right. I'd rather do that and leave the rules and regulations stand as they are going forward. I completely understand what you're saying, and I completely agree with you. But I think we can work those details outside the rules and regulations for all retroactive projects, or maybe come up with some sort of a policy. The board can come up with some sort of a policy for all pre-judgment, pre-rules and regulations, pre-Watermaster existence, and how we should handle those. Because no one wants to apply something retroactively 4 or 5 years ago.
This is the.
I agree, but let me make one more quick point, Adam. Thank you. All we suggested was adding, we're talking about these storage agreements with the contents prescribed in the rules and regs, which I just mentioned. We just want carved out from that particular form of agreement. And we agree there should be another instrument generated for the existing banks for monitoring and reporting. But it just seems to me that the contents of the storage agreements laid out in these rules is inapplicable to the present banking operations. That's why we suggested that little language.
Can you propose, Mr. Martin, can you propose a slight modification to the language that will make ABEC comfortable with the existing language so we can move on?
I think so. I don't know. The problem is I do a lot of stuff on the spot, but Dwayne's going to have to speak to what the process is, because this has been run through a committee and the full board. But yeah, the answer is yes. We certainly can add something to the language in F that talks about monitoring, and it might be worthwhile to work with Craig and Phyllis to come up with language that's going to work for them too, rather than my just setting something up that can be a target.
Public meeting, Watermaster.
Okay, if the chair of the board is agreeable to maybe qualitatively put a statement like that or a condition like that to work out that language to exclude banking operations prior to the existence of the Watermaster and the judgment, I will be amenable to that so that we can move these rules and regulations forward. I'm not interested in waiting anymore. Our engineer is saying to move forward, our attorney is saying to move forward, and I want to move.
Right.
I don't want to sit on this forever.
Well, let me speak to I'm sorry. So there is language in F. It doesn't talk about storage. I just wanted to carve out the storage agreement application. F already says to identify the projects to which these conditions apply, pre-existing banking projects will be required to provide information to the Watermaster engineer that demonstrates existing operations as of the date of the final judgment. That's a wide open invitation for the Watermaster engineer, to get all the data pertaining to the operation of these banks without having a contractual right to modify those operations. If she finds out there's material injury, that's a whole different story, but hopefully that won't be the case, since these have existed for years, pre-existed the judgment.
Well,
so I think that there's already...
This project was approved by the Huntington board too.
Yes. So I'm saying the language is already there that would provide for the Watermaster engineer's role in this. I don't know if you need any. We just would like a carve out that's very specific as to water storage agreements. Our obligation to the Watermaster is already set for it.
Let me ask our attorney, Craig, what do you recommend we do here?
Well, to try and get past the impasse, I'd like to see the rules and regulations adopted today. And it sounds like, our recommendation is in the draft rules and regulations, Adam, that it be adopted as is. But if the board cannot get unanimity on this, absent an amendment of language, we can make it subject to add language talking about being subject to being consistent with Section 9F. That might be one way of dealing with it. That's the shortest way to deal with it. I mean, we've been in discussions with Mr. Markman for a couple of times over the last month, several times, trying to get some specificity as to what the content of the storage agreement obligation of AVEC would be. And we've had discussions, but we've not put a document together. So maybe some minor amendment. I'm not really comfortable doing this on the fly for this, Adam, to tell you the truth, but just an understanding and agreement that the parties will continue to work out a memorandum of understanding on the subject of what precisely is the documentation that a pre-existing banking project is going to be required to provide to the Watermaster engineer. Just make that part of the oral amendment to the motion.
I like that idea, and that's exactly what I think can happen, so that we don't deal with this retroactive thing and the rules and regulations stay as they are for future requirements, for future banking projects. So I don't know if the chair is ready for a motion. I can make a motion.
Wait.
Is this still?
We're not quite ready.
Public comment.
Wait a minute. This OH won't have a chance to speak. This particular item is, it's been previously discussed, very important to AVEC. As a member of this board, I am not comfortable moving forward with unconclusive language. My compromise, and I too, along with with all of the AVEC board, want to see these rules and regulations approved today. My suggestion is what I could support is approving the rules and regulations with the exception of Section 9. And then at that time, we can review the actual wording, have that wording come back, and then have Section 9 come back in its entirety, and then have that approved. That would give us all the existing rules and regulations completed, and we know exactly what the wording is, because there's so much concern about the wording, what it should say, and what it actually means. I think it's important that we have that exact wording together, but it still allows us to approve the rules and regulations today. And that would be my recommendation. And I'm ready to make a motion at the appropriate time to that effect.
Yeah, before we make a motion, we probably should close the public hearing if there's no more comment, and then we can move on to section.
This is Stan Powell. And I did have a further comment.
Yes, Stan.
Can you hear me? So my comment is, I do not think this is a simple question to answer, but part of my concern is when I look at the judgment itself, Section 3.5.49, the definition of stored water, tells us that the stored water can be withdrawn and used pursuant to agreement with the Watermaster as provided in this judgment. So part of my concern is I do think the judgment itself has a requirement for what I believe is a storage agreement. And I just wanted to point that out. So that's my comment. Thank you.
So this is Jim Markman, so I always have to answer Stan with another cite to the judgment, which is paragraph 14, that says any storage agreement or application of Watermaster agreement to existing water banks cannot limit or interfere with the operations of the banks. And most of the rule in Section 9 deals with prospectively with building a bank and setting the criteria for operating it, which the Watermaster would be involved in. So there's ambiguity as to whether the kind of storage agreement that's laid out in the rules and regulations is mandated by the judgment. I don't think it is. If anything, I think the judgment calls out for a different kind of agreement, whether you call it a storage agreement or something else. And that's what AVEC is willing to work on if the board wants to adopt the rest of the rules and let us work on rule number 9, paragraph 9 going forward.
This is Robert. Robert Cush, if I could make a quick follow-up to Mr. Markman's comments. And that is, I'd like to see if the direction of the board is to approve the rules with the exception of the storage provisions, then I'd like to see a process set up which includes the stakeholders so that we can get a resolution on the storage agreements sooner rather than later. And I know that Stan Powell and I and others worked on a form of storage agreement more than a year ago and struggled to get any level of participation in what ought to be included in that agreement. And so if folks want to advance the ball here, then they really need to participate in that process of working on those storage agreements. If we need 2 storage agreements, one for existing and one for new, so be it. But let's set up a process so that we can get this to conclusion. And also, I would reiterate my earlier comments that I think it's the wrong approach to these rules to adopt them and then try to fix them later, particularly with respect to the AVEC District 40 lease language. As everyone knows, this is a unanimous board, and so whatever action you take has to be unanimous, and if you want to fix something later, that fix likewise has to be unanimous. So I think it's a much more cautious approach to approve what needs to be approved, what there is unanimity on, and to not approve those things which you know are going to need to be fixed later, because that only complicates the process. Thank you.
Was there another comment by somebody else? Let me offer this. Dwayne, you're saying that section 9, take that out and we reword it, look on language there. I'm getting all kinds of texts and things about the AVEC Waterwork 40 lease agreement is really problematic for a lot of people. I don't know if that's going to fly today. We could take that one out. I think we could get the rest of this stuff passed, and then we'd be down to a couple of items or 3 that we know we got to have some more work on.
You know, this is Adam. And speaking on behalf of Waterworks District 40, do people understand what that lease agreement is all about? I
think that's the problem, Adam. They don't. They don't know how
the lease agreement is an agreement. It's an agreement. Just a little bit of background. It's an agreement that was approved by Los Angeles County Board of Supervisors, and the AVEC board approved the lease of a portion of AVEC groundwater in proportion to the amount of annual purchases of state water project water by Waterworks District 40.
Can't hear you.
You can't hear me?
No, I can hear you.
So I don't understand.
I think people that are in, but I think people that are in the business understand it. But I think for clarity for a lot of people, where it's going to be pumped,
this is going to happen whether it's the lease is going to happen whether it's in the rules or regs or not. Mr. Wan tried to explain why it is helpful to future generation, both in AVEC and in Waterworks District 40, to allude to such an agreement in the rules and regs. I've seen rules and regs in various Watermaster boards. They normally incorporate things of that nature in the rules and regs for future generations. So it's going to happen, whether we mention it in the rules and regs or not. There is a legal agreement approved by both boards to do this lease.
I don't disagree with that, but I'm telling you, it's causing a lot of turmoil.
About nothing. I have no idea what these attorneys are talking about or why people are concerned about it.
It's going to happen.
Business that was done between 2 public agencies.
You're right. It's a contract. It's going to happen whether it's in the rules or regs. So it's causing controversy. Why don't we take it out of the rules and regs and move on?
What we wanted it for future generation when we're all dead.
I hear you, but it's causing grief and anguish.
Well, I'm going to tell you what Dwayne said. I'm not going to vote for the rules of regs if it's not there.
Well, I think there's people that aren't going to vote for them if it's in there.
Well, you know, we had tried.
Chairman, can I speak for a minute?
Yes, Derek, go ahead.
Yeah, this is Derek. So I will reiterate what Dennis is saying. I think there is a number of comments that you've heard from both council as well as from landowners that are not comfortable with a specific lease in the rules and regs. And, you know, I can speak, you know, as one that we are not comfortable with that. And, you know, I'm not, you know, not comfortable with approving this rules and regs with that portion in it. And so I think we're as adamant
why,
as you are.
Can you explain to me why, Derek?
I think you know, I'll reiterate what I think Mr. Cush said, Mr. Powell said, Mr. Atkinson have said is there is concerns that there's a specific lease being identified in rules and regs that is outside of what the typical rules and regulations are. And it individualizes something that is still not known exactly why there should be that, and it be mentioned a separate agreement within the body of the rules and regs. If it is out there, let it play out, and it doesn't need to be incorporated in a general rule and reg agreement.
But what harm will it do if it is? Did you hear me?
Adam, I think I've heard you. I think you've heard the comments. I think the angst is that why should it have to be in there? You talk about it going on for perpetuity. It's an agreement that is already bound in an agreement. It does not need to be identified in the rules and regs. It should be separate. There's no purpose for it to be in the rules and regs unless there's, you know, a concern that, you know, on your part that it's in there, but this eternal understanding it's there. It's already a legal agreement that's in between, you know, two agencies that does not need to be included in this.
I agree with you, Derek. But again, hear us out here. All what I was saying is when we all are out of that board, and AVEX staff and Waterworks staff have changed 10 years, 15 years down the road. That was the whole intent, is to put a reminder for future operators that there is such an agreement that exists. That was all the intent in there. There is nothing more than that in there. So you tell me, if you have that agreement between two agencies or you and some other public or I should say a line owner, wouldn't you want to mineralize it somehow? I know there is an existing agreement, but those are two large public agencies, and papers do get lost. Believe it or not, I've been working here for 30 years. And having given the rules and regs, at least the Watermaster engineer would say, hey, there is something here, people.
Well, I'm sorry, Kathy, were you speaking? I may have interrupted someone. Okay. I guess my point is this. It's not the place of the Watermaster board to acknowledge an agreement between two parties in the rules and regulations. You know, that agreement's between two parties, and I'm not a lawyer, and I've heard a bunch of lawyers speak. I feel, you know, as a board member and as an alternate sitting in for Mr. Flandry, that you know, it is not the place of the board to put it included in there. Those are responsibilities of both parties to go by, to be responsible for, and to document and memorialize in any manner that they feel fit, but not the Watermaster board.
Well, I don't want to be the dead horse, except it is part of the adjudication. So it's an integral part of the larger document, the larger agreement, which is the adjudication agreement. That's, I think, what everybody's missing.
Isn't it memorialized in the judgment?
It is. But that's what I'm saying.
No.
You can't make an argument that Watermaster can approve something that is in the judgment.
So if it's in the judgment, it's memorialized, Adam. We're not going to pass these rules today if it stays in there. And you're saying it's not going to pass if it comes out. So should we close the public hearing and put it on the agenda for next month?
No. If this is a hill to die on, I just want to, I've always not spoken on behalf of Waterworks District 40 all the time. I've conducted myself as somebody that spoke on behalf of the region, and I will continue to do that. But I think people need to understand that Waterworks District 40 is providing water for the people in the Antelope Valley. This is the people of the Antelope Valley that are speaking or asking for what is right for them. Not Adam or Ricky, not Warren Wallen, and not the county. If this is a hill to die on, I will go ahead and agree to remove it out of the rules and regs. But I think it's a big to do about nothing.
Well, that may be true, and there are lots of people in the Antelope Valley that have agreements with AVAC and others that aren't going in here. And I think if you could agree to take it out, I think we could move forward on it.
Except, Mr. Chair, for the last time, this was part of the judgment.
Yeah, no, it's in the judgment.
It was an integral part of the judgment.
And it's memorialized in the judgment, just like there's other special things in the judgment.
But anyway, we don't want to beat up on a dead horse. Just take it out. I'm fine with that.
Okay, so we have people ready to make a motion with language on 9 being modified and taking out, what is it, 44? I don't know, I've got 44 written down there. Is that on the page it's on? The AVEC Waterworks 40 lease agreement?
Mr. Chairman, this is Craig Pardon. Can I clarify? I want to clarify.
Please.
My understanding is that Director Chisholm's suggestion is to approve the rules and regulations with the paragraph excise that we've just been discussing, but subject to future discussion about Section 9. Section 9 is not being approved by the board today. The rules and regulations otherwise are being accepted, but not Section 9 is subject to further discussion and dialogue. That's my understanding.
And we're taking out the lease agreement?
Correct. The lease agreement, the lease agreement is Section 13C A2A, CA2A. The lease agreement language is being excised out of the agreement.
So Phyllis, did you follow all that? Where you and Craig can make the adjustments in the rules and regs?
Yes, we did. Thank you.
Okay. Dwayne, are you still prepared to make your motion?
Let's, first we got to close the public hearing and move on to item 8B, which is the actual resolution.
Okay.
It's appropriate that that's where the motion should be made. Name modification.
I was just getting tired. I wanted to move it along.
Yeah.
This is Kathy. I move to close the public hearing.
Thank you, Kathy. We have a second?
Second.
Second? Is that Adam?
Yes.
Patty, you want to do the roll call?
Director Chisholm?
Yes.
Director Ariki?
Yes.
Director Urosic? Director Messeri?
Yes.
And Director Atkinson?
Yes. Okay, we'll go to B. Possible action on resolution R 2012. Antelope Valley rules and regulations. We have a motion.
Yes, this is Director Chisholm. I'd like to make a motion to adopt resolution, whatever the number is.
2012, R 2012.
With the provision that section 9 or paragraph 9 is removed from, or I shouldn't say is not part of the approval, and that 13CA 2A be removed from the rules and regulations. Is that close enough, Craig?
Yes, the resolution provides that the resolution's being adopted subject to modifications directed by the board. And as long as the minutes are clear what those modifications are, which are two things. Section 9 is not part of the rules and regulations being approved by this resolution. And the resolution is approved subject to the excising or elimination of paragraph 13.
Yes, there's a big part
CA2.
with in the garage. In the garage.
Excuse me, somebody is talking over.
He's muted.
Okay, thank you. Let me go back. So the resolution indicates the rules and regulations are adopted with modifications as directed by the board after the public hearing. Those modifications, which can be reflected in the minutes, are two. One of them is that section 9 is not being incorporated into the rules and regulations as of now. And number 2, paragraph 13CA2A is being excised from the rules and regulations. Other than those two modifications, the rules and regulations as presented are being adopted by the board.
Dwayne made the motion. Did we have a second?
Second.
We have a second? Adam? Patty, you want to call the vote?
Yes.
Director Ricky? I'm sorry, Director Chisholm, Director Ricky,
Yes.
Director Urosic,
Yes.
Director McLaren,
She's muted.
I'm unmuting her. We have 70 people on the phone, so it's kind of hard to manage everybody.
She came off and went back on.
Director McLaren?
Yes.
Okay. Director Atkinson?
Yes.
There we go.
Okay, thank you. Item C, transfer applications. Phyllis, is that you?
Yes, it is. Thank you. The transfer that we'll talk about first is a continuing theme. We are going to discuss briefly the transfer agreement between AVEC and Los Angeles County District 40. The exhibit A on page 42 of your packet is the summary of that transfer and the resolution that you're going to be considering right on page 41. Essentially, this is needs no further introduction. I think we have talked quite a bit about this lease agreement, and this is further formalization of the lease agreement for years 2016 through 2020. Again, it's a lease agreement that was contracted between AVEC and Waterworks 40 prior to the final judgment, and this provides the Watermaster with an understanding for those years of what amounts the water is being transferred from AVEC to Waterworks 40. We provide the material injury analysis that's required for the transfer in this memorandum, We recognize that this might increase production within the central antelope sub-area cone of depression that everyone's concerned about with respect to the valley. But we did look at hydrographs within this area and provided those hydrographs as an attachment to our letter. The hydrographs were examined all around the area of well fields that District 40 operates, and we note that many of the long-term declines in this area appear to be beginning to be stabilized, and there's a lot of variable trends and fluctuations. But I think the bigger point here is that District 40 does have more than 50 wells that they are able to distribute pumping throughout this area, and the additional that we have from the transfer doesn't tell us exactly how much more or from what area within this well field the production might occur associated with the transfer. But we do recognize that District 40 has a lot of latitude here to be able to manage their well fields accordingly to make sure that we can avoid historic low water levels in specific areas and in potential areas of additional land subsidence. And we do recognize Groundwater has done a lot of well field management in the past, and we recognize that there are a lot of flexibility and operational activities that District 40 can conduct to make sure that any potential material injury is mitigated. So we do feel like that this is something that can be mitigated should it occur in the future. And as a result of that, to sort of move everything forward, we conclude that this can be mitigated and that there is no material injury to be concerned about with respect. We have recommended that the board approve it.
So, Phyllis, if there is material for mitigation, do you have to have material injury to have mitigation? Is there a mitigation plan in effect for this area?
No, it's a little chicken and egg here. We do feel like that they have the opportunity, given we've looked at their the distribution of their wells, and we looked at the water systems. There are some additional Waterworks 40 wells that are in the southeastern area, but it's a different system. But we do feel like that, given what we have seen with water levels across the area, and given the flexibility that District 40 has for their wells, that they have the opportunity to operate that in a prudent manner, and they certainly have been doing that to date. So I anticipate that they have the opportunity to do it. I don't have conditions set up for this other than to encourage them to watch their water level declines, and we certainly will watch it as well because we get water level data from District 40, and it seems to us that the well fields can be operated to avoid it, and if that doesn't happen, there are two mitigation measures that could occur. One would be to again redistribute pumping within the well fields, and then if that just simply couldn't be mitigated, then there is always the potential for looking at the balance assessment in the future. So we feel like that we would have to identify material injury in order to require mitigation, recognizing that we think that simply operation of the well field and redistribution of pumping will allow that.
Hasn't this agreement been around for some time, and we're just ratifying?
That's a large part also of our thinking and our process here. I mean, we're looking at 2000 so at history here, and recognizing that this agreement is very prior to the finalization.
Phones, unless you're speaking. We're getting a lot of background noise, so please mute your phones.
So, Adam, do you have anything to add?
I have some questions.
No.
After Adam.
Okay. I
some
trust Adam, but I don't know who the next guy's going to be.
Okay, this is Dwayne Chisholm for Babic. I had some questions for Phyllis. Understanding that Waterworks 40 does not have a pump. They can pump as much water as they'd like. Is that true?
I'm sorry, can somebody?
As a party in the adjudication, Waterworks 40 can pump as much water as they would like to meet their demands. Obviously, the question then becomes, what water are they utilizing to make that pump? I guess my point is that you made a statement that said that by providing this transfer provides additional pumping, and I'm concerned about that because Waterworks 40, like any other public water supplier or any other user of water that has the production right, can pump as much water as they would like. They are allocated a certain amount of production right, and once they exceed those production levels, then they have to mitigate through a supplemental water assessment. And so I don't know why a transfer by itself would indicate that there's going to be more pumping, because pumping is based on demand for a retail water system. The retail water system demand doesn't change just because you have additional water supplies that are transferred and available to you to mitigate future pumping. So I'm kind of trying to understand the rationale behind why there possibly could be any material injury under any circumstances, as long as the pumping is mitigated through the adjudication, whether it's through this transfer or some other that's provided.
That's a good point, Wayne.
Yes, I think your point is well taken, and there wouldn't be any reason to pump more than demand requires. We do recognize through the urban water management planning process that demand is increasing over time, and therefore pumping in this area would increase by District 40 potentially over time as well. When we do a material injury analysis, not only we consider how the water is being used and who's using it, but we also consider the potential for some portion of the sustainable yield of the basin to be pumped at locations different than where they were originally anticipated. And because that transfer now is occurring whereby AVEC could have potentially pumped this water from their locations, now this water that is again part of the sustainable yield will be transferred and pumped at another location. And so that is the process that we go through, but there's no reason to anticipate that it will cause additional pumping by District 40 with respect to their demand. Water suppliers, they pump for the demand. However, we do note that demand is going up, and so this is just the whether water can pump elsewhere versus now.
Yes, but isn't the ramp down and the reduction in production right? Isn't that the mitigation for pumping in those particular areas?
It's certainly the mitigation for the overproduction of the basin in general. The balance assessment that was added to the judgment to anticipate the potential for there to be in one specific area versus another.
Understand. Thank you for the clarification.
Thank you for the question. It was helpful.
Any other comments or questions? Looking for a motion?
Dennis, this is Robert Cush, if I could make a quick statement.
Yes.
So I want to correct something that Phyllis and I think Dwayne said, and that is that this is really a request to approve a pre-existing agreement. The agreement that's attached in support of the application is an agreement between AVEC and District 40 to exercise AVEC's Exhibit 4 rights, which emanate, as I understand it, in the west sub-area. The application that this board has before it is something different. It's an application to retroactively approve a transfer going back to 2016 of both stored surface water from AVEC's Exhibit 4 rights. So I think it's incorrect to say that this is a pre-existing agreement in whole. About 34% of the water is coming from AVEC's imported water supplies. The second component is that the testimony at trial in this case, principally from the public water suppliers, was that the area of the largest drawdown in the basin, the area that was showing the greatest impact from overdraft, was the central area of the basin where the public water suppliers were pumping most of their water. And so this is, in essence, the area where the court found specifically overdraft. And so we've got to be careful when we approve these transfers that we don't exacerbate that condition by taking credit for stored water in the west and pumping it in the central area. And I think that's what Phyllis was alluding to. And I think there's two issues which the board ought to be thinking about here today, which is this is not an application, as I understand it, for a long-term transfer under the AVEC District 40 agreement. This is for a specific period of time, which then leads me to question, when are we going to have an application to approve the long-term plan so that we're not approving these programs retroactively year after year and dealing with mitigation after the fact instead of before the fact. The second area of concern is that I think we have to be careful that we are not setting a precedent for the rest of the public where we're going to approve a transfer on the assumption that the parties to that transfer are going to self-mitigate the material injury to the basin. That seems to me to be a backwards approach. And if this board approves that approach, I don't think this board can reject another landowner or another party's request on the same basis. In other words, we're going to have a uniform rule where the transfer occurs and there are conditions of mitigation attached to that approval, or we're going to have a uniform rule which is sort of ruled by fiat where the transfer is approved and we're all going to assume that the transferor is doing what's best for the basin. I would much rather see if there are conditions of mitigation which can reduce material injury, that those be included in the resolution up front and that they be approved as part of the application rather than retroactively. Again, going back to the unanimous voting procedure, if there's a unanimous vote to approve the transfer application and then there are after the fact mitigation measures, those would also have to be unanimously approved. And there's a risk that the transfer gets approved in the first instance, but there is not unanimous consent to approve the mitigation conditions that follow. And ultimately, if we don't do a good job of managing the overdraft in the central area, then when we go to revisit safe yield after year 17 under the judgment, if there are still overdraft conditions that persist in the central area, those will have an effect on the Exhibit 4 rights because there may be a need to reduce the safe yield of the basin. Just some thoughts for the board's consideration.
This is Dwayne Chisholm. I'd like to provide some clarification with regard to some of the reasons for this application not being exactly per the agreement. One of the issues, and this is one of the items that was brought up previously, has to do with the way in which water can be pumped and utilized. This agreement is to provide Waterworks 40 with the water that that the two agencies agreed to provide each other through that lease agreement. Because we're unable, we have to use production right first before we use any other production right. During those years when this agreement was not enforced, that production water was utilized first. That allows us, that's the reason why you have these types of waters issue on this application, because that production water had to be used first. If the agency was allowed to save its production right and carry that over, you would see that this agreement would be very consistent with the original agreement, transferring only production right. And we intend to move forward with a universal production right agreement for the lease agreement that we have to move forward. This one is just to clear things up, and it is only this way because of the rules that have established the production right has to be used first. I want to make that clear.
And this agreement only goes to when, 21? Was that what I heard?
Actually, this lease agreement goes on in perpetuity.
In perpetuity, okay. Any other comments? Do you have a motion?
Sorry, Dennis. I do have a comment. This is Derek.
Okay.
I was on mute. I apologize. So, I guess my comment is I'm, I think I'm very, very supportive of transfers that both the Watermaster engineer and council have approved and reviewed that, document that they're properly. The applications are done and the analysis has been done correctly. My question is back to Phyllis, and that was brought up in a number of points, is the material injury and the reporting or management of that. The West Basin versus Central, or West Subbasin versus Central Subbasin, and the comments that were made by the public as well as by others is do we have a mechanism in place that isn't a retroactive mechanism, but a proactive mechanism to monitor that, manage it, to make sure that we aren't creating a material injury or negative impact prior to going, or, as it's starting, and then it has all parties being able to manage it. And, on top of that, I remind the board and that, we are a limited, board of funds to support both the Watermaster engineer in managing this. So how do we A, answer the question from an engineering standpoint, and B, from an economic standpoint?
From an engineering standpoint, I would suggest that working with Adam or his staff, who have been very helpful and very cooperative with the Watermaster engineer in potentially drafting a mitigation statement language that which I think is already sort of happening anyway, but it would formalize it perhaps for District 40 to indicate that they will redistribute production among their wells in their well field in order to monitor and manage the potential for chronic lowering of water levels in a particular area. And I look to Adam for input there. Perhaps he has other suggestions, but there certainly could be a condition of approval to avoid future mitigation if that's a concern. I will say this, I just will go back to the production will occur to meet demand almost really regardless of how this formalization of this past application works. The District 40 has the production rights and water and other accounts now to meet demand going forward. And so this would just simply give them additional sort of tools in their toolbox with respect to what water to use at what time. But I don't know, Adam, would you have a comment on the potential?
I just, I think, I would speak, and I hope hopefully this will resonate with those that have concerns. And by the way, the concerns that everybody's bringing are very valid concerns. We've been protective of the groundwater basin since I started my career with Illinois County Water Support in 1989. We imposed on ourselves restriction of how much groundwater we can pump because we want to protect the groundwater basin. We saw the water quality in the groundwater basin deteriorate because of over pumping. The intent of this lease, as Dwayne indicated, is really one. It should have taken place year after year after year, and it's a very small amount of water. It's something like 6,000 or 5,000, or maybe at the most 7,000 acre feet. We are committed to maximizing the use of imported water supply. We're committed to working with ADEC to conjunctively use stored groundwater during dry periods. That's the intent. We're not going to over pump the central area because we have water left. Because it's very expensive to pump when the water table goes deep. The groundwater quality becomes high in arsenic, so we can't really use it. We have chromium problem, so we can't really use it. Even if we were to be responsible and pump the heck out of the groundwater basin, all this water quality would prevent us from doing so. We're more interested in partnering with AVAC and drilling wells in the west side of the AD. And we knew that last time when we came with 4 wells and the material engineering analysis, which we disagree with, by the way, but we accepted, showed that we may have injured somebody that had a well, or maybe there were 2 wells, or how many that it is. We backed off out of the purchase of that property, and now we're looking for another property somewhere in the west side of the AD. Not to be pumping excessively on an annual basis, only to pump groundwater when there is no imported water supplies, when there is no state water private water. We would never enjoy the basin. So I don't know if this makes any sense to you. I mean, we were always for managing the groundwater basin since 1993. And I think it's about time for people to recognize that and cut us some slack. So does that help? I promise you that we're not ever going to be overpumping.
Perhaps I could, at a minimum, advise our approval letter that it states that the transfer is approved on the condition that District 40 continue their current operation of maximizing imported water during times of availability, only relying on the extra amount of production rights being afforded here for pumping during drought conditions, which is already a stated policy and sort of mission statement of District 40 anyway. But it would give the board the opportunity to always note that a mitigation measure had been enforced rather than just a sort of blanket statement for approval of a past agreement.
Yeah, I don't think it's necessary, fellas. We have to manage our water supply the way we manage our water supply. We have commitment to our customers with our water rates. and our management of the groundwater supply subject to many, many constraints: water quality, rate, availability of imported water supply, and the like. And I am not going to agree to any restriction by any agency to tell us how to manage our water supply on behalf of our customers. It's not going to happen.
I certainly didn't mean that I would restrict your operations in any way. I was just simply going to repeat your own policy statement as a formalization.
Yeah, our policy statement is our policy statement. It's subject to anything that we need to do to manage our water supply. What I've committed to is we have been on record and have been managing groundwater supply. We were the pioneer in groundwater aquifer storage program 25 years ago. We spent $7 million trying to develop that program when there was no other viable options to restore groundwater levels in the AD. So history speaks for itself. But I don't want any condition from the Watermaster on how we should manage our water supply. This agreement between ADEC and Water District 40, and it was meant to attenuate the small amount of groundwater that Water Works District 40 ended up in the adjudication. If we were pumping a lot higher than what we got in the adjudication.
Adam, this is Robert Cush. I don't doubt District 40's commitment to the basin. That is not my concern. My concern is one of precedence, which is if there's a material injury and there is mitigation that would mitigate that material injury to the basin, and we give one party a pass, don't we have to give every party in the basin a pass?
She does not foresee any material injury analysis.
Well, that's not accurate, Adam. Her report says there's a material injury which can be mitigated. That's what her report says. So I'm wondering.
Then tell us what that means.
If can you all?
We're going to pump.
I'm sorry.
How can she assume where this water is going to be pumped?
Well, maybe her analysis is incomplete. Is that what you're saying?
You don't know where we're going to pump it. Yeah, you don't know where we're going to pump it. You don't know when we're going to pump it.
Mm-hmm. Isn't that information that the Watermaster needs to evaluate the material injury?
Well, it's just groundwater rights. That we have groundwater rights. We have plenty of water that we leave behind on an annual basis. So the basin is actually benefiting from less pumping. We don't even pump our groundwater rights and return flows now. Why would we want to pump more that ADEC leads to us?
Well, I'm Adam. Again, I'm not questioning your management of the basin. I'm questioning the process under the judgment. The judgment provides that if there's a request to transfer, and that's what we have, to transfer pumping from the west to the central, that there be a material injury analysis, and that there be a.
Or Warren, can you guys get in?
What's that?
I wanted like Jeff and Warren to maybe respond to your.
Well, what I was gonna suggest, Adam, is would you be okay with some general language as a condition that said that District 40 will manage its pumping to minimize drawdowns in the central area? Some general language to that effect, as a recognition of your existing practices.
But what is the concern?
The concern, bluntly, Adam, is that your expert in the trial said that this was the most problematic area in the basin. It had the worst subsidence, the worst drawdown.
So what has changed, Mr. Fish? What has changed from the time we have approved the judgment?
I don't follow your question.
Why do we want to put these restrictions today? What has changed? What changed since the judgment? The only difference is we have a least amount of water from it.
Right.
Of whatever it is the amount. So is that the concern? You're concerned about that amount of water that would make us go hard on the basin?
No, I'm concerned about the process. When this board gets an application from a third party in a month or 2 months or a year and say, I want to transfer 10,000 acre feet from the west and I want to pump it in the central part of the basin, and I don't want to mitigate, let me finish. And I don't want to mitigate that effect. I want the same deal that the two board members got. What's your response going to be?
We've approved a lot of transfer based on our engineer's recommendation that there would not be any material engineering out.
Right? But that's not what the Todd report says.
Hello?
The Todd report says there is material injury that can be mitigated.
Yeah.
Hey, John, this is Joe.
The potential.
Hey, Joe.
There's a potential for material injury that can be mitigated. So are we going to deal with mitigation at the time of approval of transfer applications or not?
Excuse me, I didn't
First
hear.
off,
Hi, this is Warren Wellen. Are you able to hear me?
No.
Yes.
Yeah.
Go ahead. Thank you.
Still working on it.
I don't think it's appropriate at this proceeding for counsel for another party to attempt to cross-examine my client in this fashion. So I don't think it's a productive way to do this. This lease agreement, as everyone has pointed out, has been in existence since 2015. It was approved by the Los Angeles County Board of Supervisors in its capacity as the governing body for District 40. It was approved by the ABEC board. It was a material part of the global settlement that was reached in this case. The agreement's been in place since 2015. It hasn't caused District 40 to pump any more than they would otherwise. The lease agreement incentivizes District 40 to purchase state water, which is consistent with its practices for, as Adams pointed out, for decades. So I don't think anything is going to change.
No,
I think that Phyllis's report very, I think, accurately states that there is a potential for material injury. The report says, quote, material injury could occur. But it doesn't say that it has occurred. And I don't think it's necessary for the Watermaster Board to require mitigation efforts with respect to material injury that has not taken place. And the truth of the matter is, this water, the water rights that are being transferred are essentially going to be a backup. And again, they are further incentive for District 40 to purchase state water. We're responsible for providing the water supply for hundreds of thousands of people in the valley. And as I think Phyllis was alluding to earlier correctly, and I think Dwayne was as well, this just simply solidifies the options that are available to District 40, especially if we got into a severe drought, which thankfully we're not in right now. So my recommendation is that it's fine to make points and comments. I don't think it's fine to cross-examine my client, Mr. Ricky. My suggestion is that the Watermaster Board vote on this issue, and I think it should be approved. Thank you.
Any other comments?
Yeah, fine.
I need you to speak up, Jeff, a little bit more. I can't hear you.
Oh, sorry. Yeah. In place for transfer.
that process is happening now, and it's coming before the board for its vote. But it's supported by the Watermaster engineer's report and recommendation. I just want to add that there's speculation here as to what might happen is not a sufficient ground to deny this transfer request. In these types of situations, particularly with public agencies exercising their discretion and their management on these basins, they're presumed by law to comply with applicable law and policy. So it's just the opposite here. There's a presumption that on a go-forward basis, the District 40, and as well as ABEC, will conduct themselves lawfully and in the best interest of the public and comply with the judgment. The short version of all this is that your speculation as to what could happen will not be a sufficient legal ground at the end to deny this transfer request. Thank you.
Who was that was just talking?
Jeff Dunn.
Okay, thank you.
This is Dwayne Chisholm. I'd like to make one final comment, and hopefully we can move on. I want to emphasize that I don't believe that there is any material injury that's associated with this. A transfer, Cush's comments, a transfer that increases the amount of pumping from the west to the central basin is one thing. A transfer request that does not increase pumping in the central area is completely another, and I think that's the distinction. In this particular case, there is no additional pumping that will occur. There's no new production, there's no new crops, there's no new anything other than the fact that there is potentially growth in that region, and through other means, that growth is mitigated through arrangements that Waterworks 40 has, so that there's no additional impact on the groundwater basin from new development. So just because there is a transfer of water rights and one party has more water rights than they had before, material injury can only occur if that amount of pumping increases. And there will not be, that I can see, any significant increase in water pumping through this transfer. For that reason, I'm willing to support the agreement as outlined.
Are we ready to move forward?
Ready to make a motion if
Wayne, go ahead.
Ready? Yeah, I'll agree. I want to approve. I want to make a motion to approve resolution number R20-15, the transfer application between the Antelope Valley East Kern Water Agency and Los Angeles County Waterworks.
We have a second?
Second.
Adam, second. Patty, can you do the roll call?
Sure. Director Chisholm?
Yes.
Director Ariki?
Yes.
Director Urosic?
Yes.
Director McLaren? Director McLaren?
She's muted.
Yes.
Thank you, Kathy. Director Atkinson?
Yes. Thank you. Transfer application D, resolution 2016, Craig and Martha Van Dam to Five Lions Corporation and Calandry Farms.
Yeah, let me step in here. This is Craig Parton to give a little background to these three transfers that were complicated matters and have some unique features to it, which is part of the reason that the transfer applications got to the advisory committee as late as they did. there are two transfers that are from Craig Van Dam, 1 acre foot, to Calandry Farms Inc., and another separate transfer of 1 acre foot, a permanent transfer from Craig Van Dam to 5 Lions. And then there's a third transfer of 4,152 acre feet as a temporary transfer from Calandry Farms Inc. to 5 Lions. Now, the complexity of these arose because Craig Van Dam is obviously a party to the judgment and is permitted to transfer his production rights subject to Watermaster engineer review and approval. However, neither Calandry Farms Inc. nor 5 Lions are parties to the judgment, and neither of them is authorized to transfer water or receive a transfer of a production right until they successfully intervene as parties into the judgment. So there was a number of discussions in the past couple of weeks with representative of Calandry Farms Inc. about the need to intervene, and they have come to the conclusion that they agree that they need to do that, and that is part of the conditions of passing a resolution approving the Van Dam transfer to Calandry Farms of 1 acre foot and the Van Dam transfer of 1 acre foot to 5 Lions. Part of the conditions are that, number one, with respect to those transfers, and in fact the third transfer, which is from Calandry Farms to 5 Lions, all of those are subject to Calandry Farms and 5 Lions successfully intervening in the judgment and becoming parties. And the third transfer is the 4,152 acre feet proposed to be transferred from Calandry Farms Inc. to 5 Lions, is actually of a production right which belongs to County Sanitation District number 14 and is leased to Calandry. And those lease agreements are in the board packet, which indicate the ability to transfer the water. And what we have is a situation where the two of these transfers are dependent on the transferee, Calandry Farms Inc. and 5 Lions intervening successfully in the judgment and becoming parties. And the Calandry to 5 Lions transfer of 4,152 acre feet is obviously subject to Calandry and Lions becoming parties and them providing an indemnification of the Watermaster for any damage or litigation costs that might occur in the future because of entering into this potential agreement. So the Watermaster's approval of these applications is strictly subject to some conditions. You'll see them in the resolutions. And one of the conditions is that this water is not presently, the 4,152 acre feet from Calandry Farms to 5 Lions does not have a point of extraction or place of use associated with it. And so no material injury was able to be done. But the resolution and the structure that's in place for this transfer to go forward states that when that water is in fact ready for beneficial use at a location, that it'll be subject to a material injury analysis. So there's a lot of unique factors to these transfers that the board should be aware of. I'll give it to Phyllis to talk about from the engineering standpoint what was unique about it. But we feel like the resolution structures it appropriately to protect the Watermaster and the health of the basin going forward by requiring intervention, obviously successful intervention within 30 days of the resolution being passed, and Calandry Farms providing an indemnity, and Five Lions providing an indemnity to the Watermaster for any costs associated with problem issues with these transfers.
But Craig, doesn't the advisory? I mean, this was kind of a complicated one.
Yes,
a lot of moving parts. Don't you think it should go back to the advisory group since they didn't have time to review it because of its late arrival?
Well, I am certainly am open to that happening. I know the representative that has been working on this matter on behalf of Calandry Farms and Five Lions has emphasized the need for this to go forward as soon as possible. That shouldn't drive the board to make a decision it wouldn't already make.
Mute everybody.
Thank you. But that is certainly something that would be welcomed by the advisory committee to have their input on it. And that time did not permit. I noticed the chairman said that there wasn't opposition to the transfer, but that they were not able to consider it in all its facets in the limited time. I believe, and advisory committee can weigh in on.
Get back in there with the dog. Catherine, that's you.
I'll wait for the dog to get back in.
I'm sorry.
That's all right. Anyway, I believe the advisory committee spent an hour of time on it and didn't get to a resolution as to whether they had problems or were supportive of the resolutions or not. But that's certainly something that can be considered.
Are they still on?
Yes. Everybody's unmuted unless they chose to mute themselves.
I was just wondering if the advisory chairman wants to make a comment.
I'll do whatever is advised by the Watermaster.
Okay. My personal is I'd like it to go to the advisory group first. They're pretty good thinkers and they ask a lot of questions.
Yeah, I'd like to hear from Phyllis. There's the one, this is Adam.
Go ahead, Adam.
So I said I'd like to hear from Phyllis. I'd like to hear Phyllis' opinion, scientific opinion.
Phyllis, maybe, sorry to interrupt you. This is Derek, and apologize, Adam. Just for clarity, Craig, Calandry, and I know John Calandry is one of the board members, but this is not that Calandry, right? It's his son.
Correct. It's his son, Brandon, and his entity that he is, I believe, CEO of is Calandry Farms, Inc., which is not a party to the judgment, is not an Exhibit 4 right holder. So there's total separation there.
Okay. Thank you very much. Sorry there, Adam and Phyllis.
That's fine.
No problem. I do have some things I would like the board to recognize about this transfer. It was a very difficult process for a variety of reasons. Craig summarized the issue of no material injury, so I don't have any more comments with respect to that. But I just think that there were so many irregularities associated with this application, and I would strongly want to go on the record here to say that we just can't, for future transfers, I'm more worried about this somehow setting a precedent for what we're going to get in the future. And we really need to to get this cleaned up. And I think the rules and regulations will help quite a bit now that they're approved. But with this particular transfer, our applicant didn't have the water to transfer. They weren't a party to the judgment. They didn't have the water right. And so instead, they presented a lease with the application. The Watermaster engineer cannot possibly be in a position of having to interpret a legal document such as a lease. It was complicated, and we had to spend time going through that and trying to understand it. We had to get Craig involved because we couldn't understand the process. So I think that we need to make it clear that all transfer applicants in the future have to have the party that they're wanting to transfer. The issue of neither party being a party to the judgment was handled by Craig immediately and noted that they needed to intervene, and they agreed, and that's great. But the bottom line for us is that we were in a position, pressured by the applicant's attorney, frankly, to get this to the advisory committee prior to even knowing if LA County SAN agreed with the amount of water that was being transferred. In fact, our first two conversations with them, we couldn't reconcile the water accounting. From the Watermaster engineer's point of view, we have two primary responsibilities when we get transfer agreements. One is to make sure that the water that is being transferred is actually in the accounts by the applicant, and that we can fully understand what amounts of water are being removed and added to whatever accounts there are. The second is the material injury analysis. And so in this particular case, the first was much more important to us than the second, because again, they will have to do a material injury analysis. The transferee will have to do one when the water, the place and the amounts of water to be used are put forth. But I don't think that we should be pressured into providing incomplete information to the advisory committee. I objected strongly that we were pressured to figure out for ourselves that the lease agreement allowed for this transfer to occur, and it all could have been managed more appropriately to have a transfer from LA County SAN via Calandry Farms to Via Lions, if that's what all of the parties really wanted to do. Having said all of that, I am more concerned about the future than I am for this particular transfer. We didn't do I have no recommendation for that. So thank you for letting me discuss the irregularities, and hopefully future transfers won't cause this much analysis, this many telephone conversations, this much a memo, etc. Okay, thank you.
Yeah, it sounded to me like this item maybe shouldn't have made it to the agenda.
Hi, this is David Leventhal. I'm the attorney that was referred to. I'd like to address some of her points, as well as my general understanding of what any hesitation might be. First of all, I'd like to apologize for any extra brain damage that was associated with this. I would just ask that everybody please be patient. We're figuring this out, just like the Watermaster Board is itself, with new rules and regulations. We're figuring this out as we go along too. The current application was actually identical to an application that was approved in terms of the standing of Calandry Farms, Inc. to transfer water on behalf of LA County last year. And so all we did was just follow a template that was already approved. We weren't trying to make anybody's life difficult or consume anybody's time unnecessarily. But I just want everybody to know we're following a template that had already been approved by the Watermaster Board. The only irregularity that I was aware of was there was some concern about whether or not the county had vested authority to Calandry Farms, Inc. to transfer this water. That, although we filed the application back in May, actually prior to the May board meeting, this issue about Calandry Farms, Inc. standing to transfer water on behalf of the district was not brought to our attention until I think the day that the packet was delivered to the advisory committee. As soon as that issue was brought to our attention, we immediately contacted the county, and that resulted in a confirming email from the county sanitation district, which clarified, making it crystal clear that Planty Farms Inc. does have agency authority to transfer this water on behalf of the district, and also authorizing and specifying the amount of that water. So again, we apologize for the issue, but just ask that everybody be aware. All we did was follow the template that had already been approved last year. As soon as the issue was brought to our attention, which was the day of the packet being presented to the advisory committee, we immediately scrambled, and within a couple days thereafter, we got the letter from the county. I want to say it was 2 business days after this issue was first brought to our attention, we were able to get that confirmation, which was no small miracle in and of itself. And then in terms of all the other issues, so both parties have agreed to intervene, so that solves that. And then in terms of material injury, there is no material injury because it's just a transfer. I believe there was comments to that effect in the resolution and in other memos that until there is an actual point of extraction identified, there can possibly be a material injury because this is just an exchange of rights. And so a material injury analysis either isn't necessary or can be done, on the fly and just say, well, there's no point of extraction, so it's unnecessary and there is no material injury. And in terms of the amount of water that is being transferred, again, that issue wasn't, the question wasn't brought to our attention until the day that matters were presented to the advisory committee, but all of those accounting records had already previously been provided to the Watermaster. They're already in the Watermaster records. Planty Farms Inc. has timely filed all of its reports, and all of that math is already in the Watermaster's records, and I believe there was a short narrative to that effect in the transfer request form or my covered email, and certainly in my conversations that followed the filing of the application and during my follow-ups. So again, I understand that there was a combination of a couple of different quirky things that caused some hesitation and some eyebrows being raised, but really, this is not a complicated transaction. It's just a transfer of a production right. It's not it's not causing any. It can't possibly have any impact on the basin because there's no point of extraction, and it's just a transfer. But really, again, there was a couple of side issues that we were able to sort through. I think that the resolutions drafted by the Watermaster's Counsel, Craig, adequately address everything. And although we had a little bit of a bumpy ride, I'll call it, I think it's perfectly set up to be approved by the Watermaster Board. Thank you.
Any other comments? Do we have a motion? You want to send it back to the advisory board? You want to move forward? What's your pleasure?
This is Dwayne Chisholm from ABAC.
Yeah, I like that motion.
Who's that?
Go ahead,
Dwayne. Adam.
Adam?
Yes.
No, go ahead. You said, go ahead.
Okay, this is under consideration for the resolution R20-16. I'll move for approval of the transfer for R20-16s from Craig and Marta Van Dam to Five Lions Corporation and Calandry Farms. And per the per the staff report and the conditions outlined by Phyllis and Craig.
I second.
The second? Okay. All those in favor? Roll call for.
I hold on. Hold on 1 second here. This is Adam.
Okay.
I need our engineer to clarify the setting a precedent, because you tell us, you alluded to the fact that
the amount of that water, that was the associated with the Watermaster engineer. And it was not clarified. We did, I will just take exception to a couple of comments that were made. It was absolutely not clarified in the first 3 conversations that we had with the water rights holders. And it was only after a certain amount of time where there was additional communication that we knew what it was. I am only trying to make sure that going forward, we not get ourselves into a situation again like this.
Okay, are you recommending to the board that you do this?
But there's no material injury analysis associated with the transfer for the reasons that have been discussed. So we don't,
Right.
we are not saying that we just have no recommendation. There's no material injury analysis. We have, since this process has been going on to I think Friday, we finally were able to confirm with Los Angeles County Sanitation District, who is the water rights holder for this water involved in the transfer. We were able to finally on Friday confirm with them that that water was available to Calandry Farms for transfer. So that was the last detail that we felt that the Watermaster engineer needed to get in place, and that was done on Friday. So there's no material injury analysis, and therefore we have no recommendation with respect to the transfer.
Adam, this is Craig. Just to follow up on Phyllis's comment, the resolution is not, the engineer is not recommending approval, but if a board so approves, the engineer wants to have the 4, and I agree, and drafted the 4 conditions that are in the resolution that have to be fulfilled if this transfer is going to go forward. There's got to be intervention, that there's going to be no effect of the transfer until there is successful intervention, and then material injury analysis at the time the point of extraction is determined, and that it has no precedential value is the 4th condition. So it's unusual. We don't condition transfers very often, but this one has several conditions, as does the one you'll be considering next. Very similar, the Calandry Farms to 5 Lions has several conditions, including indemnification that is a result of the passage of the rules and regulations that we just did earlier. So I just wanted you to know that that's in the resolution.
And that
Okay,
is,
yeah, no, I appreciate that.
included
That's great.
in my motion. I want to make that clear.
Okay.
And to be clear, the parties to the transaction are aware of those conditions, and we don't have any problem with them at all.
Okay. All right.
We most definitely comply.
Dennis, this is Derek. Just to make sure, Craig, we are just, I think, Dwayne's motion is into regards to R20-16, right?
Correct.
Right.
Which is Craig and Marta Van Dam to V Lions and Calandry, correct?
It's actually Craig Van Dam. Marta is not a part of this transaction.
Okay, sorry, I was just reading off of the agenda.
Yes, and Patty Rose was very adept at noticing that the notary signatures by Craig Van Dam alone, and he is the owner of the production right pursuant to the contract attached to the transfer application.
Thank you.
Yeah.
Okay. Everybody's had their questions answered? Ready for the vote?
Yes, sir.
Patty?
Okay, so we have the motion by Dwayne, seconded by Kathy. So, Director Chisholm,
Yes.
Director Ricky,
Yes.
Director Urosic,
Yes.
Director McLaren,
Yes.
and Director Atkinson.
Yes.
Thank you.
Okay, the next one, same players. Craig, go ahead. Phyllis or Craig?
Yeah, I think we set this up already in the discussion. The 4,100, and I'll let Phyllis weigh in on the material injury issue, but very similar issues again. The proposed transfers from Calandry Farms, Inc. to Five Lions, and it's actually of a production right which belongs to LA County Sanitation, has been leased to Calandry. And no point of extraction is identified in the application, which, as I understand it, means that Phyllis is not doing a material injury analysis. So there are conditions again with that approval that are in as part of the resolution. Your review, page 123 and 124. And there are 5 conditions. And Mr. Leventhal just indicated that his clients are comfortable with those provisions. As one of them, obviously, intervention. The transfer has no force and effect until Calandry and Five Lions each has successfully intervened. The production right that's being transferred is not to be utilized by Five Lions or anybody else until a material injury analysis is done. It's a temporary transfer from the district to Five Lions, with Calandry acting as an agent of the district, and then the discussion about not being precedent in any way. Let me indicate that the indemnification language I have not submitted to Mr. Leventhal yet, because I wanted to obviously see if there's going to be approval of the resolution, but this is all contingent, obviously, on successful indemnification language, which I don't anticipate being a problem, and that'll is part of the resolution.
On that issue, I'll just say, if you've seen one indemnity agreement, you've seen them all. I'm sure it won't be a problem for us to agree on that language.
So that's the report in terms of the structure of this transaction. Phyllis may have additional comments about this particular transfer. I don't know.
No, I don't have any further comments. Thank you.
Okay, any other questions by anybody? Do we have a motion to approve R 2017?
This is Dwayne Chisholm. I make a motion to approve resolution R 20-17 for the transfer application between LA County Sanitation District number 14 to Five Lions operations via Calandry Farms lease, and subject to the conditions that were spoken of and contained within the resolution.
Thank you, Dwayne. Got a second?
I second that.
Okay, thank you. Kathy, ready for the roll call vote?
Yep. So, Director Chisholm?
Yes.
Director Ricky?
Yes.
Director Urosic?
Yes.
Director McLaren?
Yes.
And Director Atkinson?
Yes. New production application.
Can I just make one comment now that it's been approved?
Yes.
We have an agreement that the motion to intervene will be filed within 30 days. And so I'll be updating the board on this. We obviously have great incentive to make sure the motion to intervene is filed, giving everyone an opportunity to weigh in on this with Judge Komar if they see so fit. And we want to make sure the transfer is effective upon successful intervention. So we'll be watching that carefully. It'll be an item to update you on next month.
Thank you.
And it'll be my highest priority. I'll obviously be in communication with you on that, Greg.
Yeah.
Thank you, board. Thank you, everybody.
New production?
Hi, this is Kate White. I'll take the new production one. The resolution R20-18 for the approval of new production for Copart Incorporated starts on page 199 of the packet. And the exhibit A to that actually lists what the APNs are, is on page 201. And Copart would like this new production for industrial use, and they're in the central Antelope Valley sub-area. And the facility is currently undeveloped and is proposed to be used for the short-term storage and sale of damaged and undamaged used vehicles. The facility is going to have an office, sales building, a parking lot, and a shipping area, and a storage lot for these cars. And the water is going to be used for irrigation, fire flow, and possible potable use for up to 15 employees. And the applicant provided a detailed summary of what they anticipate the water use will be during construction and during the initial operation of the facilities. And those numbers are listed on page 204 in my letter in the application. And water use will range initially from 21.6 acre feet, and then once the facility is in operation, it'll reduce to 12.2 acre feet. There are two sources of groundwater that the applicant two sources of groundwater production locations that the applicant would like to use. One is a abandoned well that they're going to try to re-equip and use during construction, and during when their new production well will be installed. And then once the production well is installed, they'll seal up the abandoned agricultural well. Figure 1 in the packet shows the location of where this is in the central Antelope Valley. That's on page, I think, 207 of the packet. And so it is in the central area, located near a large cone of depression. But as Phyllis kind of mentioned regarding the other transfer that occurred, that there is a long-term decline in this area, but recent water levels have been stabilizing. And we recommend approval of this application because Copart will be paying a replacement water assessment for the water that it's using, and that Copart will have to intervene in the judgment because they are currently not. Are there any questions on this one?
Yeah, Katie, this is Adam.
Hi, Adam.
Do you have an idea when the new well will be drilled?
I think once approval occurs, I think they'll probably get a driller. Can you hear me?
Yeah.
Okay. So once the approval occurs of the application, I think they will get the driller, get the well drilled, and so I think it might be a year. I'm not quite sure, but that's why they want to use the agricultural well initially for construction. And is somebody else trying to speak?
No, I don't think so. I think somebody was speaking on the phone or something. So my main concern is I couldn't find any record on the existing well. I even contacted the engineers that did the report on it, and I didn't know if it had how it was constructed. That's why I'm asking, do you have any records on if the wells have a sanitary seal or?
For the old agricultural well, no. I do not have any records on that one.
Okay. Yeah, so as long as they don't end up using that well on long-term basis, a year is not a big deal, but beyond a year, I would have a problem with using an old ag well that we have no record of. I'm concerned about groundwater quality. We already have enough arsenic and other issues in that area, so that we don't want to add any man-made pollutants. So I don't know how comfortable are you about the new well?
I think that's a good concern. They did say that they will properly abandon that agricultural well once the new production well is installed.
Right. But how do we ensure that a new well will be drilled?
I think that's what they're asking for in this application, but I guess we can.
Oh, they are. I thought they're asking. I thought they were asking for something right and then intervene.
Correct, but the application does detail the new well that they will be drilling, and they do say that they will properly abandon the agricultural well once the new well's drilled.
Okay, I'm sorry. For whatever reason, I couldn't find it in the documents here. Okay, thank you for clarifying that. Appreciate it.
Okay, oh, you're welcome. Thank you for your question.
Okay. Everybody satisfied with the information? Do we have a motion to approve R 2018?
And this is Dwayne Chisholm. I'll approve. I'll make a motion to approve resolution R 20-18, new production application.
Thank you, Dwayne. Second?
Second.
Kathy, thank you.
Okay. Can I ask Craig one last question? Do they have a timeline when they would intervene as well? 30 days or whatever it is, Craig, or you don't know?
We need to follow up on that, Adam. We do not have a timeline for that. And that's been a concern that has been raised by staff about following up on intervention. So it's definitely going to the top of the board. And I'll represent to the board that I will inform them in writing that we expect the motion to intervene, absent extenuating circumstances, to be filed in 30 days.
Thank you.
Patty?
Okay. Director Chisholm?
Yes.
Director Riki?
Yes.
Director Urosic?
Yes.
Director McLaren?
Yes.
And Director Atkinson?
Yes. Monitoring well application.
Thank you. This is Peter Thompson. I'll take that one.
Thanks, Peter.
On page 237, you have the resolution for the approval of 2 monitoring wells. The first of those is from Palmdale Water District and LA County Sanitation District, and that's for a monitoring well on the proposed site of the Palmdale Regional Groundwater Recharge and Recovery Project. And it's currently would be a test well for water quality purposes, and could eventually turn into a production well for the purposes of assisting with construction on the site. As noted in Palmdale Water District's letter, that if that were to occur, then a new point of extraction application would come before the board. So this is just simply for the approval of the monitoring well for water quality purposes. Also in your packet, starting at page 249, is the request for Village Mobile Home Park. And theirs is a monitoring well for water quality purposes as well. They have a difficulty with high arsenic in their current groundwater well, and they're doing a test well to determine if a new well would be feasible and if they could mitigate for that arsenic. That monitoring well that they're proposing would be abandoned after it had served its purpose. And if you have any further questions, I'd be happy to answer those.
Any questions? Do we have a motion to approve the monitoring well, resolution R 2019?
This is Dwayne Chisholm again. I'll move approval for resolution R-20-19 monitoring well application.
Thank you, Dwayne. Do we have a second?
I'll second it to break that. Adam?
Okay.
Is that Derek or Adam?
Yeah.
Okay, Derek. Thank you. Any other questions? Patty?
Director Chisholm?
Yes.
Director Ricky?
Yes.
Director Uroki?
Yes.
Director McLaren?
Yes.
And Director Atkinson?
Yes. Okay, Craig, my favorite topic.
Yeah, as I indicated at the beginning, Director Atkinson, this is going to be part of my report. It's not an action item. I can talk about it now, but it's probably better to finish your action items and then I'll report to the board on that.
Well, I think we're done with those.
You still have meter compliance.
Oh.
You've got
those are just reports? Everything else is just a report.
Well, I'm fine to report as long as we understand it's not an action item. Phelan submitted a letter April 29th that's been to the advisory committee and has been circulating, and it's about inquiring about the possibility of whether the board would be receptive to Phelan using transfer water to meet its replacement water obligation for 2016 to 2018. And the very mindful of the fact that this involves other board members and who are presently in litigation with Phelan. So it's not, as I thought about it and considered the input from the advisory committee also, that opposes any effort to enter into what may amount to a settlement agreement in part is inappropriate to do. So I, in light of today, is a good illustration of how complex the matters are and detailed and take a long time to work through and various issues, that this board should not be in the process of giving advisory opinions about what Phelan should do concerning its replacement water obligation. If Phelan wants to approach various parties about a possible settlement direction, they can do so. If they want to submit a transfer request application, they can do so, and the board can vote at that point. But I think in light of the pending litigation and the advisory committee's recommendation, that further open discussion on the topic of whether Phelan should be qualified for transfer water to meet its replacement water obligation is not appropriate. So I'm keeping that off, taking that off any action, requesting anything from the board, which may necessarily require board members to disclose advice from their attorneys relating to the litigation. They have no interest in doing that. So with that said, that's the report on Phelan. And that's the important point. There's nothing to vote on today. There's no transfer request teed up. And I don't want the precedent being set of this board entering into discussions about something that isn't teed up for it to decide up or down.
All right. Meter compliance.
Hi, this is Kate. I'll take that one. On page 269 of the packet is a list of parties who we have incomplete meter documentation from. And on that list, there are about 34 original parties, the ones that were listed in the judgment, that we're still working with to get their meter documentation. And then it's also listed about another 18 parties, which include new production parties, small pumpers who are pumping more than 3 acre-feet per year, and then a couple unauthorized pumpers that we're also working with. All I can say is that we're still working with these parties to get their meter documentation completed. That's all I have on that one. Are there any questions?
Thank you.
Okay, welcome.
Update on outstanding annual production reports. Matt or Peter?
This will be Peter. I'll go ahead and take that one. Starting at page 271, we have the past due amounts that was requested, that staff put that together. Matt did cover those in earlier in the agenda in the AR and aging summary. Below that, you have the missing production reports. So that's all laid out for the board to see. If you have any questions, I can answer some general ones, and if they're specific, we may turn those over to Patty.
The only question I have, Peter, what effort are you doing to pursue those that have not reported production?
What have we been doing for those that have not submitted production report?
Yeah.
Well, we continually reach out to them and try to get them to, report. At the beginning of the year, when we sent out the 2019 annual reports, we sent out 16, 17, and 18 if they needed to report those years also. We can only do so much. We have made phone calls, we have sent certified letters, and we have, we just continually try to reach out. But
did we send them one of Craig's letter?
I think I think that's something that we'll need to discuss as to something coming directly from the attorney for both missing production reports and metering. And then maybe because of rules and regs, maybe we can put some bite behind it, really, that we can get some responses.
Yeah, Adam, this is Craig. That's really my responsibility with staff help to follow up on the lack of production reports. We've obviously been focused on getting the rules and regs and looking at some of the major parties that owe major assessments and starting to reach out to them. But we need to, and I intend to give to the board, if not next month, the month after, a plan of going after the key players that owe a substantial amount.
Okay. Thank you. Just,
yeah.
We don't want to be insane, so to speak.
Yeah.
Thank you.
Thank you. Letter to Lahontan.
Yeah. Good afternoon. This is Matt. So at the May Watermaster meeting, the board requested that staff prepare a letter to the regional board requesting that we be informed on all projects that may have an impact on the groundwater basin. So staff worked with Phyllis. She helped out by putting the draft letter that's in your packet, began on page 274. And we're just looking for input from the board to make sure they are comfortable with sending this letter to the regional board.
I'm good with it.
You're good. Okay. Good. Okay. Sounds like we have a consensus, so we'll change the date on it and get that sent out in the next couple days.
Thanks, Matt.
Thank you.
Administrator's report.
So we have 3 items to update the board on. The first item on small pumpers, the administrative assessment update, and Patty is going to give an update.
Okay, we sent out letters back in May, and to date we've identified approximately 600 small pumpers where we received the information on their parcels, their some well information, and their assessments for the past 5 years. Any questions?
Did you receive any money, Patty?
Do I get to keep getting that money?
Of course you do. Half of it, not all of it.
Angel and I should get some bottle of Excedrin PM or something. Not a big deal.
All right, thank you, Patty. The next item is talking about the voting process, landowner rep and their alternate. So as you know, Director Atkinson's seat is up for election this fall. So we are, based on the rules and regs, we are going to begin that process this week. So our schedule is to send out the nomination information and ballots for that next couple days. Those nominations would be due July 15th at 5 p.m. And then July 20th, we would email out all the ballots as well as a statement of qualifications for the nominees. And then those would be due back August 10th at 5 p.m. And then August 11th, we would meet with the Inspector of Elections, who we've identified as City of Palmdale representative. It's the same individual that did the last election. We would go through and open and count all votes, and then that information would be provided to Craig Parton to pass on to the report. And then our goal would be to have that new board representatives take their seat in August or September at the latest. So that's just an update on that. And then item 9C, we were planning to have the 2019 financial audit for the board to consider this evening, but there were several comments that came out of the advisory committee. So we pulled that from an agenda, and we're going through those comments now with the auditor. And the plan is to bring that back to the board for consideration at July meeting. So that's all I have to report, unless there are any questions.
Any questions for Matt?
Nope.
Thank you.
Thank you.
Watermaster Engineer Report, annual update.
Yes, hi. I know this has been a very long meeting, and everybody's been asked to go through a lot of complex issues today. And if I'd realized that, I probably wouldn't have even prepared a slideshow. But this is very short, and we're just going to run through it briefly. A little bit about the annual report draft that is out now for everyone's review and comment. This is looks like. It was posted on the Watermaster website on June 3rd, 2020, and it has the same organization as we've had in the past, whereas most of the primary sections in the text are shown here, and then all of the water accounting is shown in the appendices as usual. Going to the next slide, I do have some what I think is nice features for the annual report this year, that we have made some improvements in how we are demonstrating our Watermaster's engineers' primary responsibility of safe yield components monitoring. Thanks to working with staff, we now have a better understanding of exactly where production is occurring with respect to both locations and volumes, as indicated by this little bubble map here, with red being the highest locations of production, and then going all the way down to the small green values, and you can see the amounts shown there in the legend. We also have little purple circles on the map showing areas where we do not have production reporting. So this gives us a really good opportunity to better understand what's going on within production monitoring in the basin. And then going to the next slide, we also have a better opportunity now. We're improving things to be able to understand where small pumpers are located and are pumping. Thanks to District 40 for preparing what I think is a monumental task of tracking and understanding where these small pumper parcels occur within the basin. We are refining some of these parcels in some areas where we've recognized some issues. And this is going to support our future monitoring of the small pumpers as described in the judgment. So we're really moving the ball forward, we think, on being able to do better production monitoring. Next slide, please. We also have a new item in this annual report regarding subsidence monitoring. You might recall that we had historical information from USGS, but they really didn't have an ongoing monitoring program for land subsidence throughout the subbasin. And now we have the opportunity to pull in satellite imagery from the Department of Water Resources, which is now available online. They've contracted with a processing firm, Tree Altamira, and they have provided updated recent subsidence monitoring throughout the entire state of California, focusing on their groundwater basins, of course. These are maps that indicate vertical displacement. In California, we have tectonic activity, so in some places we're actually going up instead of down, but we can use these vertical displacement maps to help us look for areas of negative displacement, which may indicate either elastic or inelastic subsidence. And I think the news is relatively favorable for our basin. We can see two colors on this map, yellow and light green. The yellow essentially means no negative vertical displacement at all. So no issues, no problems, nothing even remotely indicated from the satellite imagery. The shaded green areas do indicate small amounts of vertical displacement. This varies significantly throughout this green shaded area. In many areas, it is so small that it is fractions of an inch. The maximum subsidence is in a small area that is up to a little more than half an inch. This is for 2019. So these areas of, I know that you're not looking at it now, but in the annual report, we have identified the areas of historical subsidence, and these areas of green that we see on recent subsidence are in the same areas. So we probably have some additional legacy subsidence occurring from historic lows in the basin, as well as a little bit of elastic subsidence, which will likely rebound. I think this is just giving us a good opportunity to track this on an ongoing basis and determine from year to year if we see any continuing issues or problems. So those are the new items that we have with respect to stay field monitoring in the subbasin. And then if we can go to the next slide, we are continuing to do additional water level monitoring in the basin using the USGS monitoring events that have been occurring on an ongoing basis, and which this Watermaster participates in and partially funds. And this just, again, the way that we've selected these hydrographs specifically as being representative, the process for doing that is described in the annual report. It's essentially the same wells that have long periods of record that we can provide this ongoing tracking of trends and fluctuations in the subbasin over a 23-year period. These hydrographs date back to 1997. We do see rising trends in areas of banking, no surprise there. But the other thing is that 2019 was a relatively wet year, as was 2017. And as a result of that, we have more runoff coming into the basin, as well as more imported water availability for recharge. And as a result of that, we're starting to see some flattening of the declining trends in the central sub-area that we had seen mostly declines for in the past. So a little bit of good news there. And if we go to the next slide, we can see water level indicated on this map by color coding. Areas of water level rises over this last year are shown by the blues and purples, and the areas of water level declines are shown by the yellows and the oranges. And so you can see that the basin is really dominated by the banking projects, which bring in quite a bit of water, and as a result in water level changes from year to year. So this is just the indication that we've had additional imported water for banking opportunities in the subbasin, as well as additional local projects that are coming online. When we look at these numbers, I just want to make the point while we're on this map, we're going to see that the southeast subarea in particular, it has indicated a broad level of decline. And I want to point out that that's indicated by our data, but we have had sparse monitoring data in this subarea in the past, and we've also had high water levels in this subarea in the past. So I want to just point out that while we go through the calculations for the southeast subarea, as we do all of the subareas in the basin, we've got a little more uncertainty associated with our process in that area. And so the calculations that I'm talking about are summarized on this next slide's table, which is represented as table 6 in your annual report. And this just shows our annual change in groundwater volumes. I'm getting used to now using the term groundwater volumes instead of changing groundwater and storage. If you ask any hydrogeologist in this state, they would say, yes, of course, changing groundwater and storage is exactly what we're doing with respect to these kinds of analyses. But we had comments on our annual report that said, you know, using the change in groundwater and storage is a little confusing because we have so much stored water in the basin. And stored water, of course, is a term defined in the judgment. And as a result of that, I'm trying to get used to stop saying changing groundwater and storage and change that to change in groundwater volumes. And so we've made that change in our report, and that's indicated here. And overall, we have, again, rises in several of the sub-areas as a result of banking, mostly in the West Antelope and also in the Central Antelope area, and then some smaller declines associated with the Southeast Willow Springs and Rogers Lake sub-area, where we have, again, I'll just emphasize this, a little less data. In some cases, these calculations are based on only 1 or 2 wells, and so that's a little bit of uncertainty there. But overall, we've had a positive change in groundwater volume in the basin over the last year for the reporting period, so good news associated with that. And then I've just, on the next slide, I've listed additional sort of new items in the appendices. You can just review those if you'd like for your reference. This may also just may keep you from having a comment as to, you know, what is this and this looks new type of thing. But we have we've made organizational changes that we think are helpful and that we think provide more information in tabular form for people to quickly go to the appendix and be able to see additional things about the accounts, as well as some of the applications, including transfers that we're now documenting in a little bit of a more detailed way. So those are the sort of summarized summarized items that we have in the annual report. And then this next slide just simply summarizes some of the comments that we received on the June 3rd draft. And so we're incorporating these comments, and we'll be posting a new draft on the website with these comments made. And we do have a couple of other additional comments in it, other than the ones I'm showing here, but these are really the parties that provided more formal, significant comments. And so I've just sort of summarized the comments and the changes that have been incorporated into the draft document on this slide. Answering questions if anybody has them, but I just wanted you to at least know what was different in the June, what changes had been made to the June draft. And so the final annual report slide simply provides the schedule again. We will be posting a revised draft annual report on July 1. Please review that and provide us any final comments that you might have on the draft. by July 15th so that we can incorporate those and better understand those, ask questions if we need clarifications, so that we can hold a public hearing on July 22nd and have a really near final document available for everyone to see and be able to review at that time. We will post based on comments that we get from the final comments that we get from the public hearing. We'll incorporate those and post a final 2019 annual report on July 29th. And then if anyone finds any errors or typos, then we can quickly make those. But that draft that we post on July 29th is very, very, very final in our minds, because it is due to the court on August 1st, which is a Saturday. So that means that we only have a couple of days after our final posting of the final to submit it to the court, probably on Friday, July 31st. We'll work with the general counsel to make that happen. And at that time, we'll also be submitting the annual report to the Department of Water Resources as required for our SGMA reporting. So I've run through that very quickly and appreciate you hanging in there with me at such a late hour. And I'll be glad to answer any questions that you might have on the annual. I've worn you down. I did have that last. I didn't have any questions. Thank you. I did have that last slide that just popped up, and I don't see any need to go through this again. I think we've already talked about this. It's just my continued harping on, gee, wouldn't it be nice if we had compliance with production reporting?
Anything else?
That's it.
All right. General Counsel.
Nothing further. I just want to remind the board that I'll, pursuant to its decision on the rules and regulations, we'll be posting the final draft on the website the next day, and I'll be bringing a motion for approval in the court. Certainly have it on calendar, hopefully by our next meeting.
Cool. Good job. Any requests for future agenda items?
Not at this time.
And so exhausted from this long meeting and can't have any. That's good.
Yep.
Okay. I think we're adjourned. Thanks, everybody.
Thank you.
Bye.
Thank you all.
Thank you.